Contract Act 1. When a contract is breached, the aggrieved party may claim various kinds of damages to compensate for the loss suffered. These damages can be categorized as follows. A. Compensatory damages. These aim to put the aggrieved party in the same position they would have been if the contract had been fulfilled. For example, if a buyer purchases a defective product, compensatory damages would be the cost of repairing or replacing the product. B. Consequential damages. These are losses that occur as a consequence of the breach and are beyond the immediate transaction. For instance, if a contractor fails to complete a construction project on time, resulting in financial losses for the client, the consequential damages may include lost profits or additional expenses incurred. C. Nominal damages. These are small symbolic damages awarded when there is a technical breach of contract but no significant loss or harm suffered by the aggrieved party. D. Liquidated damages. In some contracts, the parties may agree in advance on a specific amount of damages to be paid in case of a breach. These are called liquidated damages, and are predetermined and specified in the contract itself. E. Punitive damages. These are rarely awarded in contract cases. They are meant to punish the breaching party for their misconduct and deter similar behavior in the future. Punitive damages are more commonly associated with tort law rather than contract law. 2. The rules regarding time and place of performance in a contract are as follows. A. Time of performance. Unless the contract specifies a particular time for performance, it must be done within a reasonable time. What constitutes a reasonable time depends on the nature of the contract and the circumstances of the case. B. Place of performance. The general rule is that the performance must take place at the place specified in the contract. If the contract is silent on the place, the performance must take place at the location where the party who is supposed to receive the performance is situated. 3. Discharge of contract by subsequent impossibility refers to a situation where an unforeseen event occurs after the formation of the contract, making it impossible to fulfill the contractual obligations. In such cases, the contract is discharged, and the parties are no longer bound by its terms. Examples of subsequent impossibility include the destruction of the subject matter of the contract, the death or incapacity of a party essential to the contract, or a change in law that makes performance illegal. 4. Contract of indemnity and contract of guarantee are two distinct types of contracts. A. Contract of indemnity. In a contract of indemnity, one party, indemnifier, promises to compensate the other party, indemnity holder, for any loss or damage suffered by them. The indemnifier's liability arises only after the loss or damage occurs. For example, an insurance contract is a contract of indemnity. B. Contract of guarantee. In a contract of guarantee, one party, surety, promises to fulfill the obligations of another party, principal debtor, in case the principal debtor fails to perform. The surety's liability is secondary and arises only when the principal debtor defaults. For instance, when a person guarantees the repayment of a loan taken by someone else. 5. Bailment refers to the transfer of possession of goods from one person, bailer, to another person, bailee, for a specific purpose, with the goods being returned or disposed of according to the bailor's instructions. There are different kinds of bailments. A. Bailment for the benefit of bailor. In this type of bailment, the bailor receives the sole benefit from the bailment. For example, lending a car to a friend for personal use. B. Bailment for the benefit of bailee. Here, the bailee receives the sole benefit from the bailment. An example would be borrowing a book from a library. C. Mutual benefit bailment. In this type of bailment, both the bailor and bailee derive some benefit from the transaction. For instance, when a person leaves their car at a mechanic's shop for repairs, both parties benefit from the arrangement. D. Gratuitous bailment. This type of bailment involves the bailor transferring possession of goods to the bailee without any consideration or benefit. For example, borrowing a neighbor's lawnmower for a day. 6. The duties of the finder of lost goods include: A. Taking reasonable care of the goods. The finder must protect and preserve the lost goods from any damage or loss while in their possession. B. Attempting to locate the true owner. The finder should make reasonable efforts to find and return the goods to their rightful owner. C. Reporting the find. Depending on the jurisdiction, the finder may be required to report the finding of lost goods to the appropriate authorities or follow specific legal procedures. 7. The duties of a bailer include: A. Disclosing known defects. The bailer must inform the bailee of any known defects or dangers associated with the goods being bailed. B. Compensating for necessary expenses. The bailer is responsible for reimbursing the bailee for any reasonable and necessary expenses incurred while fulfilling the bailment purpose. C. Indemnifying the bailee. The bailer must protect the bailee against any losses or liabilities arising from the bailment, unless otherwise agreed. 8. The rights of a bailer include: A. Right to receive the goods back. Upon completion of the bailment purpose, the bailer has the right to reclaim their goods from the bailee. B. Right to terminate the bailment. The bailer can end the bailment at any time if the bailee breaches the terms of the agreement or if there is a valid reason for termination. C. Right to compensation for unauthorized use. If the bailee exceeds the scope of the bailment agreement or uses the goods without permission, the bailer may be entitled to compensation for any resulting damages. 9. The duties of a bailee include: A. Taking reasonable care of the goods. The bailee must exercise reasonable care and ensure the goods are protected from loss or damage during the bailment period. B. Using the goods only as authorized. The bailee should use the goods strictly within the scope of the bailment agreement and not for any unauthorized purposes. C. Returning the goods. Once the bailment purpose is fulfilled or the bailment is terminated, the bailee must return the goods to the bailer in the same condition as received, subject to any wear and tear resulting from proper use. _.